Welcome to Roman Manor. This lesson will explore subject matter jurisdiction. Specifically, it will cover federal question jurisdiction. You can also check out the law cited via the links in the description below. And with that, let's get to it. A quick preface. If you haven't watched the lesson on subject matter jurisdiction basis, I suggest you do so before proceeding. It will help you put this lesson into perspective as this lesson builds upon that one. That said, let's discuss federal question jurisdiction. This relatively brief lesson will proceed as follows. We will start by defining federal question jurisdiction before examining some procedural aspects applicable to it and all bases of subject matter jurisdiction. Lastly, we will mention the areas of the law where the federal courts have exclusive jurisdiction. Federal question jurisdiction is the most commonly invoked basis for subject matter jurisdiction in the federal courts. Black's Law defines this concept as, quote, the exercise of federal court power over claims arising under the U.S. Constitution, an act of Congress, or a treaty, unquote. This definition mirrors the statutory authority for FQ jurisdiction. That statutory authority, 28 U.S.C. Section 1331, states that, quote, federal district courts shall have original jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States, unquote. Stated simply, federal question jurisdiction is invoked by a plaintiff whose claim arises under the U.S. Constitution, congressional statute, or treaty. Given those definitions, we can say that the plaintiff's claim must be the result of some perceived infringement upon a federal right particular to him or his cause of action, which has its origin in federal law. But when must the plaintiff make that determination? The plaintiff's cause of action must state the federal question giving rise to FQ jurisdiction in a well-pleaded complaint. Federal Rule of Civil Procedure Rule 8 requires the plaintiff to state a claim for relief with three components. The complaint must contain 1. A short and plain statement of the ground for the court's jurisdiction, unless the court already has jurisdiction and the claim needs no new jurisdictional support. 2. A short and plain statement of the claim showing that the pleader is entitled to relief, and 3. A demand for the relief sought, which may include relief in the alternative or different types of relief. When determining whether FQ jurisdiction is appropriate, it is immaterial as to what the defendant's answer or anticipated defense may be. Whether federal question jurisdiction is appropriate in a matter or not is determined solely as it relates to the plaintiff's disposition. We will discuss pleading in a separate video, but keep in mind that any pleading made must fall within the standards set forth in Twombly-Iqbal, namely that the claim must be plausible and not merely conceivable. There are instances that are well decided as falling under the exclusive jurisdiction of the federal district courts. We've listed these areas and provided the statutory authority as well, so take a look if you wish. These instances are cases involving most admiralty issues, bankruptcy, patent and copyright litigation, postal matter lawsuits, IRS matters, cases where U.S. consuls and vice consuls are defendants, as well as litigation under the Securities Exchange Act. In essence, federal question jurisdiction is the province of those areas carved out by Article 3, Section 2 of the U.S. Constitution. Federal question jurisdiction is rather straightforward in its application. To reiterate, it applies where the plaintiff's case arises under the Constitution, laws, and treaties of the United States. That's it for this lesson. If you found it helpful, give the video a like and subscribe to the channel. Leave some comments below and check back often for more content. As always, thank you for visiting Roman Manor and have a lovely day.